All right, let's call to order the City of Bella Vista Board of Zoning Adjustments. Call the roll, please.
Ellis,
Here.
Farner,
Here.
Klesson. Here. Sudbury,
Here.
Portillo,
Here.
Wagner, Lloyd,
Here.
All right, we do have a quorum. First on our agenda is our March 10th meeting minutes.
Make a motion that it be approved as submitted.
Got a motion from Farner,
Second.
second from Klesson. All in favor say aye.
Aye.
Opposed? Meeting minutes are approved. Next up, we have unfinished business, zoning variance 2025-57690, a variance request on a side building setback for a proposed single-family home at 5 Swallow Lane. Planner LaRue.
Good evening, Commissioners. Yes, so this property is located in eastern Bella Vista near the Metfield Clubhouse on Lot 9, Block 3 of the Sunderland subdivision. The applicable zoning code we are looking at today is Section 109-75-3C, which requires a minimum side setback of 7.5 feet parallel to the property lines. Of course, the applicant is requesting a variance of this side setback to build a single-family home on an existing foundation. A little bit more of the background of the property. Constructed prior to 2007, the previous 3-bedroom home at this site was destroyed by fire in October of 2022, with demolition beginning in March of the following year, leaving only the foundation. Per Code Section 109-132, the owner had 1 year to rebuild in order to maintain the non-conforming status of the house. However, the status had been lost. The new proposal includes a new 3-bedroom home that would reuse the existing foundations. However, this would locate the eaves of the front corner of the house over the side setback line. Swallow Lane is a dead-end cul-de-sac labeled as a residential street per the master street plan and is within a neighborhood area. Staff finds that the fire is not of the applicant's actions and provides hardship for development. Reconstruction of a single-family home at this site using the same foundation aligns with the spirit and intent of the R1 district. Staff, all legal notifications were met. No public comment was given, and staff is recommending approval.
Any questions for staff?
welcome Jack, for the record.
Thank you.
All right, if not, would the applicant go ahead and come up to the podium and state your name and address for the record, please? And we'll let you expound on the staff report if you'd like to.
Good afternoon, Alicia Lewis on behalf of Palisades Construction as their counsel. The only thing I would add to the report is the reason the status was originally lost after the fires, there was a delay in getting the original plans from the ACC. Once we obtained those plans, they couldn't be utilized, so we had to retain an architectural firm to draft new plans, and they did confirm that the foundation is structurally sound and there's no other issues with that. And then once we obtained that and received the approval from the architectural firm, we applied for this variance.
Any questions for the applicant? All righty, do we need to conduct a public hearing on this one since this is under unfinished business?
We would have already done that, didn't we? No, so we don't have to do another one.
All righty. If not, are there any questions or comments from commissioners? Not, can I get a motion to approve zoning variance 2025-57690?
So moved.
Got a motion from Portillo, second from Farner. Call the roll, please.
Farner,
Yes.
Portillo,
Yes.
Wagner,
Yes.
Lloyd,
Yes.
Klesson,
Yes.
Sudbury,
Yes.
Ellis.
Yes, your variance is approved and staff will get with you on next steps.
Thank you very much.
You betcha. Next up, we have public hearing or zoning variance 2025-58179, a variance request on the front setback for a proposed single-family home at 5 Walney Drive. Planner Grady.
Good evening, Commissioners. This property is located in the central area of Bella Vista city limits near Highway 72. The applicant is seeking a variance on Section 109-75B3A, which stipulates the minimum front setback from all property lines shall be 20 feet unless otherwise stated on the subdivision plat. The applicant requests to reduce the platted 20-foot setback of Lot 17 by 5 feet to establish a 15-foot setback due to the specific placement, topography, and lot size. The applicant is proposing to construct a 2-bedroom, 1,243 square foot single-family home with a 33-foot long driveway, 2-car garage per this 15-foot setback request. Staff found that other properties within the Quantock Hills subdivision are zoned R1 single-family residential and have setbacks ranging from 15 feet to 25 feet. Walney Drive is Walney Drive is a local residential street per the master street plan, and the site falls within a neighborhood area per the future land use plan. Staff finds that the .26 square foot lot falls under the .32 square foot R1 minimum lot size, which means small. Additionally, the site is challenged by a ravine and steep topography on the rear northeast boundary, thus pushing the development forward, and it creates a hardship that is not the result of the applicant's actions. Additionally, other factors such as the state-approved septic design are causing a need for the forward placement. Finally, the request to build a two-bedroom, single-family home meets the spirit and intent of the zoning ordinance, and the 15-foot setback request is aligned with R1 lots nearby. No public comments were received. The staff is recommending approval on this, based on this analysis. Excuse me.
All right, any questions for staff? Is the applicant present? If you could come up to the podium and state your name and address, please, and we'll let you add to the staff report.
My name is Cameron Hagan, and I've owned the property for 3 years. And, I think that there will still be plenty of room for parking cars out front with the minimum setback of 15 foot, with the property line being 10 feet in from the blacktop to begin with. It shouldn't be an issue. That's all I got.
Any questions for the applicant? If not, if you go ahead and take a seat real quick, sir, we're going to conduct our public hearing, then we'll call you back up. All right, at this time, we'll go ahead and open the floor for any public comment on this particular project. We give the applicant or the public 5 minutes to speak, and we'll go ahead and open the floor. All right, seeing none, we'll go ahead and close the public hearing. If you would come back up to the podium, sir. Commissioners, any further questions or comments of the applicant or staff? Anything that you would like to add, sir? All righty. If not, can I get a motion to approve zoning variance 2025-58179?
So moved.
Got a motion from Farner,
Second.
second from Lloyd. Call the roll, please.
Portillo,
Yes.
Wagman,
Yes.
Lloyd,
Yes.
Plesson,
Yes.
Sudbury,
No.
Farner,
Yes.
Ellis,
Yes. Staff will get, your variance is approved. Staff will get with you on the next step, sir.
Thank you.
Thank you. All right, that finishes our new business. Do we have anything for open discussion?
not for the board.
All righty, with that, we stand adjourned. All right, let's call to order the City of Bella Vista Planning Commission meeting for April 14th. If you call the roll, please.
Ellis,
Here?
Farner,
Here.
Plesson,
Here.
Sudbury,
Here.
Portillo,
Here.
Wagman,
Here.
Lloyd,
Here.
All right, we do have a quorum. First on our agenda is our March 10th meeting minutes.
I make a motion they be approved as submitted.
Got a motion from Farner,
Second.
second from Klesset. All in favor, say aye.
Aye.
Any opposed? All right, meeting minutes are approved. Next up, we have our public input session. This will be an opportunity for anybody in the public to address the Planning Commission for any published or non-published items. We'll give each person 5 minutes. If you would, state your name and address for the record, please. All right, seeing none, we'll go ahead and close the public input session. First up, we have for unfinished business waiver 2025-57693 and large scale 2025-57496, both associated with a Dollar General located on Highway 94 outside, within our planning area, but outside our city limits. Planner LaRue.
All right, so this property is located in the far northeast corner of Bella Vista, just outside city limits of Lot 1, Block 1 of the Auckland subdivision. The applicable regulations we're looking at in this application is Section 107-317E, which does require a minimum distance of 250 feet between access drives on major and minor arterials, as well as subsection F, which requires commercial developments along major arterials to have a designated right turn only lane, as well as 107-162, which sets forth the requirements of large-scale developments. The applicant is requesting a waiver of 107-317E for the proposed access drive. To accommodate the new Dollar General and its to accommodate the new Dollar General, in lieu of the required 250 feet distance from the adjacent driveway to the north, the applicant is proposing 73 feet in order to meet the 250 separation requirement of the intersection located just to the south. They are also requesting to have the left turn, I'll go ahead and just run through it a little more. The site will be served by POA Water and on-site wastewater management. Arkansas Highway 94 and 340 are designated as major arterial streets per the master street plan. There is no zoning requirements because this is outside city limits in the planning area. The applicant did submit a traffic analysis, and the site is expected to generate 99 trips a day. As a reminder, all the building permitting shall be handled by the Benton County. Grading and drainage permitting will be handled by the City of Bella Vista. There was no outstanding technical comments at the time of this report, and staff is recommending approval so long as the Planning Commission approves the waiver request.
All right, any questions for staff over the report? Can you real quick explain what you were saying about the left turn movement or the right in, right out, or I didn't catch all of that?
Right, so the applicant was requesting a waiver of the requirement that on access drives onto major arterials to have a designated right turn only lane. They, of course, they want to keep the left-hand turn lane, so they're going to be asking a waiver from that requirement.
Okay, so they're asking to do a left turn and a right, okay.
Correct.
Yeah, I got it now. All right, any other questions for the staff? All right, as the applicant present, if you would, go ahead and come up to the podium. State your name, who you represent, and we'll let you add on to the staff report.
Good afternoon. My name is Cody Sexton with Blue and Associates, representing the developer. And I don't think I have anything specifically to add that Connor didn't bring up already. We pretty much need the two variances for access to make the property developable, especially since the unique circumstances with the property being right at the state line and the adjacent liquor store to the north just kind of has a large swath of a no man's land of pavement that stretches to the north, so it's mathematically impossible to get that original length of whatever the 250, the 200 that's required in there. So
Have you gotten your RDOT permit yet?
we have not. We're waiting on contingent on your guys' approval because the county has already approved everything contingent on Bella Vista's approval. I've already discussed the site with Ben Kerwood to great extent. We were just waiting to get the city and the county approvals before we handed it off to the state.
Okay.
Just in case there was some minor change, if you guys wanted to move something 5 feet, then I'd just have to start over with state
Sure.
again.
Understand. Any other questions? Yes, ma'am.
I think you'll find that the county planning board has not approved everything because we're waiting for this to happen first.
Yeah, I think that's what I tried to say.
Said that kind of backwards.
Understand.
We had I think the county meeting 3 weeks ago, and then, yeah, it was approval contingent upon city's approval.
Gotcha.
Did I say that right?
That's right.
Close enough, we got it. Any other questions or comments? All right, if not, can I get a motion to approve waiver 2025-57693?
So moved.
Got a motion from Portillo,
Second.
second from Farner. Call the roll, please.
Wyman,
Yes.
Lloyd,
Yes.
Klesson,
Yes.
Sedbury,
Yes.
Farner,
Yes.
Portillo,
Yes.
Ellis.
Yes. Can I get a motion to approve large-scale 2025-57496?
So moved.
A motion from Farner. Second. Second from Sedbury. Call the roll, please.
Lloyd,
Yes.
Klesson,
Yes.
Sedbury,
Yes.
Farner,
Yes.
Portillo,
Yes.
Wagman,
Yes.
Ellis.
Yes. All right, you're approved, and staff will get with you on next steps as far as the city's concerned.
Thank you very much.
Thank you. Next up for new business, we have a waiver 2025-58040, a waiver request for the number of permitted access drives for lots less than 151 feet on 96 Melanie Drive. Planner LaRue.
All right, so this property is located in the southeast area of Bella Vista city limits on Lot 15, Block 5 of the Merritt subdivision. The applicable regulation is 107-317D, which permits a maximum of 1 access drives for lots with street frontage less than 150 feet. The applicant is requesting a waiver of this code section to improve a second non-conforming gravel driveway. One more on the background. The applicant is required to improve the non-conforming driveway with an existing corrugated metal culvert that was established before the ordinance of the city. Due to the increased trip generation for the proposed attached garage, excuse me, I said that a little backwards. The applicant is proposing to improve their driveway because of the new attached garage. The subject lot has only approximately 110 feet of street frontage, which of course does not meet the 151-foot requirement to have 2 accesses. The center line is over 25 feet from the adjacent driveway center lines. Existing access features in place prior to the adoption of this ordinance shall be brought into compliance with substantial improvements, like I had already mentioned. If the Planning Commission approves this waiver, staff will note that the first 20 feet in length shall be paved with concrete with an 18-inch asphalt approach to the city street. City engineering permits will also be required should this waiver be approved. Although it is not best practice to increase the number of curb cuts, Melanie Drive is a residential unclassified street per the master street plan that does experience low to minimal traffic volumes and is a low-density neighborhood area. The applicant, additional permits may be required from the ACC. Some outstanding technical comments. Village Wastewater did resubmit comments addressing the lift station and the sewer connection. And they, with the latest plans that they had saw, they did approve as long as the sewer tap and the lift station were not obstructed. And that is everything.
Any questions for staff? So am I understanding correctly, this second gravel driveway was put in before we became a city?
Correct.
Okay, so it's an existing non-conforming driveway. So what has prompted the need for the waiver then?
With the proposed attached garage, just the change in trip generation and the number of times that driveway may be used. Also improving any improvements over, I think, is it 50%, would require, just improvements to be made, any proposals.
Okay.
And just a note for the record, it was built after the city was established. It just was built prior to the section 107-317. So it was built in 2008.
Okay, all right. Is the applicant present? Yeah, if you go ahead and come up and give us your name and address for the record, and we'll let you add on to the staff report if you would like.
Evening, my name is Greg Thomas, 96 Melanie Drive. The only thing I'd like to add is 2008 was as far back as I could get a Google image of that driveway. I don't actually know when it was put in. Neighbors have said like soon after the house was built in 96 or 97, so it's been there for a long time.
We have any questions for the applicant?
Yes.
Yes, sir.
During the work session, I think I remember you saying that you were going to concrete the entire driveway. Is that correct?
Well, I didn't want to do anything with it, but they're requesting it be brought up to code, so they've requested the first 20 feet, and I think it's kind of silly to have 20 feet of concrete going into stone, so.
So you're saying that you're going to do the concrete all the way?
All the way to the new
Thank you.
garage is the plan now.
Okay.
So there's a new garage being built in the end of the lot, and this access is the new garage, am I understanding the use?
Yes, well, I already have a shop in the basement underneath the house. I'm just expanding that. I don't really foresee any increased traffic in that driveway is we just use it for occasional parking when people are over visiting. You know, it's just access into that garage, so.
Have you worked with the neighbors, any objections?
The neighbors I've talked to have no objections on it.
Do we have anything on record?
We don't have, on waivers, we don't require a public hearing. Yes, ma'am.
Seems to me it'd be quite easy to come from the existing driveway and curve around to this rather than putting a second curb cut. Is there a reason you choose not to do that?
Because the driveway's already there. My front lawn is 31 by 33 with a tree in the middle of it. So essentially, by putting a driveway from the one driveway over, I have no front yard left.
It seems to me that we've turned down a number of these second driveway requests previously, so I'm just trying to come up with an alternative solution for
Right.
you.
That was brought up, and I mean, if my street frontage was bigger, it probably wouldn't be an issue, but just routing the driveway through the front yard, I mean, the front yard's gonna be nothing but driveway. I think curb appeal wise is just, especially since there's already a driveway that's been there for 20 years.
I have a question for staff attorney. Do we have anything from a precedent perspective that allows us to approve something like this because of its existence prior to code being established?
I don't remember. I mean, there's been a lot of projects over the years, and I don't have a recollection of all of them to say we've done this before, or we haven't done this in the same circumstance. I can just tell you that the driveway pre-existed any regulation of the additional driveway, so obviously, I think at this point, the city could not require the driveway that exists to be removed. I mean, they have it, and so they've established that. Because of the improvement that they're wanting to do, and the fact, I assume that it's more than 50% of, is it a widening of it? Is that?
There's four things. But it's improvements, I think, over 25% of the existing GFA, and then trip generation, if you're gonna use it more, things like that.
Okay. So that's what gives rise to you having to consider this. So I don't know of a precedent that says that you've done it like this before or that you haven't, and that's just based on my memory.
But we have
Of course,
nothing on the books that says if it did exist, you're automatically
No,
able to do
no,
it.
I don't, we don't have anything in
I
the
guess
books
that's
anywhere
the
that says anything's automatic, in terms of approval of a matter to which you have judgment in which to make.
Okay, that answers it. Thank you.
And I'll note too, just since it was said, yes, 107, 317 items have been denied, but secondary accesses have also been approved. Those waivers have been approved since I've been here as well. So both cases, it's a case-by-case basis. So I just wanted to make sure both circumstances have happened.
The last one I remember we denied was one that got built, like, as they were building the home just a couple of years ago, and they were literally parallel to each other. And it was to start parking a bunch of other cars, and we were like, no, you can't do that. The code told you you couldn't do it, and you did it anyways, and you came in and asked for forgiveness. This is a little bit different. This is an existing driveway, and I'm pretty sure it was there before 2008, just looking at the 2008 photo.
It wasn't there in the 2007 aerial imagery.
Yeah, I mean, but it's been there before we had the ordinance in place.
Correct.
So really, he's asking us, can he add on to his house for additional shop space? That's really what's in question, because he wants to do that. He has to get a waiver on his existing driveway.
Okay, that's clear. Thank you.
Yeah. Any other questions or comments? If not, can I get a motion to approve waiver 2025-58040?
I make a motion, we approve the waiver so long as the driveway will be concrete.
Got a motion from Farner,
Second.
got a second from Wagnon. Call the roll, please.
Klessen,
No.
Sedberry,
No.
Farner,
Yes.
Portillo,
Yes.
Wagnon,
Yes.
Lloyd,
No.
Ellis,
Yes. That is approved 4-3.
thank you.
Staff will get with you on next steps. Next up, we have waiver 2025-58092, waiver request on several retaining wall requirements for an existing terraced wall at 39 Bradford Drive. Planner LaRue, you got a busy night tonight, sir.
I know, a little bit. So this project is located in the central area of Bella Vista city limits of Lot 11, Block 4 of the Randor subdivision. Applicable zoning code is 107-342D, pertaining to retaining walls inside drainage and utility easements, as well as 107-342E and F, which sets the minimum distances for retaining walls from structures, property lines, and so forth. All right. So the applicant is seeking a waiver of the requirements above to allow an existing terraced retaining wall to remain that is stabilizing an unpermitted cut. Going into some of the background, the applicant is seeking the subject waiver for the retaining walls. They total 52 inches of height to stabilize the approximate unpermitted 4-inch cut. No grading was proposed in the 2022 GEC permit, and it is unknown how close the septic system is located to the walls in the back of the home. Since the time of the wall's construction, staff has been working with the applicant to achieve compliance with the house currently still in its temporary certificate of occupancy pending the yard or the wall approval since April of 2023. An engineer certification letter is included in your packet and does approve of the design as constructed. Should this waiver be approved, additional approvals may be required prior to wall permitting. This waiver request is not considering the private easement that the wall sits in, just the setback. Staff is recommending that prior to the retaining wall permit being issued, that an updated survey is submitted showing the exact locations of the wall from the house to the property lines as well as from each other. The new survey should also include spot elevations.
All right, any questions for staff?
Were these walls permitted before they were put in?
They have
No.
not been permitted yet, that's why they're here as of now. We can't permit them until the setbacks are waived.
So we're doing a setback waiver on the retaining walls?
Correct, all of them, from each other, from the property, from the property lines, and from the structure.
But those walls are there.
Correct. That we're trying to bring into compliance. This is one of those situations that, it's one of the few remaining that we've been cleaning up, hopefully one of the last, but we cannot move forward with a permit until the setbacks are waived.
This one dates back from 21, about right?
The project, correct. The walls, I believe, communication's been going on since circa 2022, 2023, for the walls specifically.
This is new single family, new construction? Or is it?
It's new single family. It is occupied. They have a temporary certificate of occupancy, contingent upon the wall permit before they get their full C of O. And that was also, just to state for the record too, this temporary C of O was given before the city's new policy was established that temporary C of Os will not be issued for retaining walls or driveways.
But the building permit was issued with this item undecided.
Yes, the building permit was issued, the cut was not disclosed, so therefore the retaining walls or the stabilization method was not disclosed at the time of building permit.
Staff would also add, the homeowner does own the property, the adjacent property as well.
You're saying the adjacent property to the northwest?
Correct, yep.
Are those the only ones that are in question, or the ones highlighted in green on the survey?
It would be for all of the walls. They're noted here as approved, but there was no approved retaining walls at this site.
So even the pink ones even the pink ones in the back and the front are not in compliance?
Correct, they were built without a permit, or not disclosed on the GEC.
push this to the lot line? Is that how I'm interpreting this?
The ask is to just allow the wall to remain and have the waiver so they can move forward with receiving their C of O.
For setbacks.
Got
You
it.
are only considering setbacks at this moment. You're considering setbacks from the property line, from the structure, and from each other because they're terraced. However, did staff, just to be transparent, just because we cannot see where the septic system is in relation to these, we can't confirm if it meets or does not meet the leach field. So, but at this time, you're only considering property line, structure, and each other.
And have they submitted a septic map? The as is it, that's the field, thank you.
We have not received a plan that shows both, though, just to answer, I think, the question you were about to ask.
Any other questions for staff?
What's the impact if this is denied on the real estate owner?
If this is denied, we can't permit it,
Can't permit,
can't permit the
house,
walls,
occupancy?
and then thus the final certificate of occupancy would not be issued. So it would continue to sit on a temporary.
And then if it continues, it would be in a non-conforming state. And, I mean, if this goes its full logical legal route, then lawsuits and to remove it or to remove the structure.
Has your
Most
office-
likely to remove the wall because there's no question about the structure. So the wall would have to be taken out since it was it was in the setback and unpermitted. Nothing good. It's terrible.
No, there doesn't seem like there's a lot of good answers to this one.
Unfortunately, this is not the first one like this that we have seen.
Yes.
That has come out of the early 2020s. We even had one lawsuit we had to settle that had some same issues.
Has the legal office done a fiscal impact on the risk? Is there a risk assessment or have we
No,
done it?
I haven't, we haven't gotten anywhere close to that.
Yeah, I just was curious.
We're
You know,
kind of
it's
the
not,
next step in the process.
We have to understand that there was an internal control problem in terms of inspection and letting things get put where they were put as things are being looked at along the construction process. So you've got that. But then, you know, it's not the government, and the code says this, it's not the government to remind the builder, hey, you're about to screw this up. I mean, they do bear responsibility for complying with legal requirements. They can't say, well, you didn't tell me. I mean, they are still on the hook to comply. So, like I say, it's nothing good that's going to come from this if it's denied, but it may need to be denied. I mean, that doesn't mean that it shouldn't be. And that's really all I can offer. But no, I haven't done any kind of, I don't see there being a fiscal impact on the city. But, you know, I don't know who built this house and who currently owns it, but I would expect fully there would be litigation between those parties as well, or in addition.
And just to add I forgot one step. If you guys do deny this, the applicant does have 30 days to appeal your decision to city council. So if this doesn't pass tonight, they'll have 30 days from today to file with the city clerk and appeal for them to consider an overturn of your decision.
Is the owner the builder? Or are they separate entities?
I believe they're separate. Mhm.
Well, it's an unfortunate situation.
Do we have the applicant present tonight? Well, that makes it real easy for us. We have no applicant present. Can I get a motion to table waiver 2025-58092 to our next planning commission meeting?
So moved.
Got a motion from Farner,
Second.
second from Klesson. Call the roll, please.
Sudbury,
Yes.
Warner,
Yes.
Portillo,
Yes.
Wagner,
Yes.
Floyd,
Yes.
Plesson,
Yes.
Ellis.
Yes. Would you all, staff, would you please let the applicant know that we expect them to be here at our next meeting? Or we will take action and they can just deal with our attorney's office after that. Next up, we have lot split 2025-57550, a lot split near 9248 East McNelly Road. Planner Hyatt.
All right, thank you. This property is located east of Bella Vista city limits and is parcel 18-08019-005, located along East McNelly Road. This applicant is proposing to split this parcel, creating two new lots. Lot 1 is roughly 2.48 acres, and Lot 2 roughly 2.57 acres. The subject parcel currently has an existing home, garage, and shed that would be split out from the second lot, which would then be vacant. Various drainage and utility easements have been dedicated to the public along the front, sides, and rear per city requirements. Right-of-way widths have been previously met for McNelly Road, and lot area requirements for Benton County are being met as both lots exceed the 1 acre minimum. This section of McNelly Road is classified as a collector per the master street plan, and adjacent land uses around the parcel are all Benton County and part of Bella Vista's planning area. No outstanding technical comments at this time, but due to the analysis above, staff does recommend approval.
All right, any questions for staff? All right, is the applicant present? We are communicating the need to attend, right?
Correct.
I'm hoping no one's out in the vestibule or taking a bathroom break.
I haven't seen anybody come or go.
My only concern, or it's not really a concern, is that if you table this, we have these code requirements, we have to take action within a certain number of days. And I just want to make sure that these applicants don't bear the benefit of that time running out for some reason.
Well, I mean, I don't feel like if they're not here, they're not.
And you can table it for one meeting without being concerned about
Yeah.
that. But if we end up with it again.
Oh,
we
no,
definitely
if they don't show up again, we take action as a denial.
Well, you'll
most
need to
likely.
vote, you'll need to vote on it after
Yeah.
considering it.
Yeah. I don't know, commissioners, it's a pretty cut and dry deal, no question.
Yeah.
It might be at its.
I don't see a reason to table it.
Nor do I.
All right,
Can staff confirm the date of complete before we do that?
say
Real
that
quick.
again.
Can we confirm the date of complete submittal before we, because it would, I'm thinking it might be close to where we have to take action tonight. Where we pull the
I
record
think
really
we're
quick.
prepared to take action.
Okay, okay.
Can I get a motion to approve lot split 2025-57550?
So moved.
Got a motion from Bertello,
Second.
second from Farner, call the roll, please.
Just to confirm, since this is a development, a subdivision, if it meets all code requirements, we have to approve it. There's no waivers or variances submitted with it.
Well, this is just a lot split, right?
Correct. Subdivisions count.
Yeah,
Okay.
So we're doing it.
All right.
yeah, we have a
I mean, it
motion and
falls
a
under
second to
subdivision code.
approve. Call the roll, please.
Farner,
Yes.
Portillo,
Yes.
Wagner,
Yes.
Lloyd,
Yes.
Plesson,
Yes.
Sedberry,
Yes.
Ellis,
Yes. All right, if y'all would get with the applicant on the next step, please. All right, next up, we have plat 2025-57679, a property line adjustment near number 5 Oldham Drive. Trails Manager Workman.
Thank you. This subject site, containing 190 acres, is situated west of the intersection of Oldham Drive and Bella Vista Way. The applicant is requesting a property line adjustment to clean up the existing property lines and to establish lots 1 through 4 of the Anderson Heights subdivision. Lot 1 measures 167.7 acres in size and is split zoned, containing the following zoning designations: R1 Single Family Residential, RE Residential Estate, SPR Special Residential, P1 Conservation, and C4 Shopping Center District. This lot will be fronted by Oldham Drive, a subcollector, Bella Vista Way, a major arterial, and Cunningham and Sunset Drives, both of which are unclassified streets as identified by the adopted master street plan. Lot 2 is proposed at 15.3 acres in size. It's zoned C4 and is fronted by Sunset Drive. Lot 3 measures 3.8 acres in size, is zoned C4 and is fronted by Bella Vista Way. And Lot 4 is proposed at 3.6 acres, is zoned C4 and is fronted by Bella Vista Way. All lots proposed meet the bulk and area regulations of the underlying zoning districts and are all 4 fronted by a public street. Dedications have been made as required, and no vacations were proposed with this application. No public comments were received, and staff comments have been satisfied by the applicant. Therefore, staff is recommending approval of this request.
Any questions for the applicant, or for staff? Okay, if the applicant come up to the podium, please state your name and who you represent.
Hi, I'm Brittany Gillard. I work with CEI Engineering at 2600 Northeast 11th Street. Thank you, Megan. That was wonderful. Here to represent for the property line adjustment. Yeah, if you have any questions, let me know.
Any questions for the applicant? All right, seeing none, can I get a motion to approve plat 2025-57679?
So moved.
Got a motion from Farner. Second. Second from Sedberry. Call the roll, please.
Portillo,
Yes.
Wagner,
Yes.
Lloyd,
Yes.
Plesson,
Yes.
Sedberry,
Yes.
Farner,
Yes.
Ellis.
Abstain. All right, the plat's approved. Staff will get with you on next steps. All right, that finishes our new business. Do we have anything for committee reports?
Not at this time. I did want to just remind, the committee reports is a portion of the agenda from our bylaws that's set aside in case you guys decide to create a little subcommittee to focus on things. So we won't have a committee report until you guys create a subcommittee to focus on a side project. Just to help clarify a little bit.
All right, thank you. Open discussion.
I just wanted to provide a brief update. They kind of go hand in hand, so I threw both on there, and Attorney Kelly is more than welcome to add to or change or edit anything that I say. But as you know, the Development Code Reform Project was put on a temporary pause due to the active legislature that we've been experiencing this spring. There was a lot of property rights / land use zoning, building. There's a lot of inspection requirements, things of that nature that basically all revolve around the development world. So we decided it was a good idea to press pause. We are investing money into this, so we don't want to pay redundant fees to go back and change something if we have to change it in August anyway. So to be more fiscally responsible, I guess you could put it in that shape or form, we decided to pause. They have until Wednesday. I don't think the date has changed to submit anything else. However, at this time, most of the development-related legislature has either been deferred, if it's still revolving through the window, or it's been approved into an act, or it's been sent to another committee for study until the next legislature. The ones that have been passed so far that we have already submitted to the Friesen Nichols team for updating, make sure that our new code complies with it, is the ADU limitation restrictions, which is now Act 313. That affected 109, so they now have that in their hands. Senate Bill 505, which is the administrative rezones, was an item I wanted to discuss with you all tonight after I get through this update. That is sitting on the governor's desk right now. It has not been signed into an act yet. We're just waiting to see what her decision is on that. It's passed through both bodies. And then the House Bill 1510, which is the big one that we've been discussing, eliminating your territorial jurisdiction in the planning area. That has been handed over to the reform team to work into Chapter 107. So any mention of the planning area is going to be ripped out. It's only going to be focusing on the city limits for Chapter 107 is basically the big change of that. The big bill that I've been sending you guys updates on, House Bill 1754, is set for a hearing tomorrow morning at 8. However, it's on the deferred list. So essentially, there's no movement on that right now. The other one that I was sending you emails about, the zoning reform or the permit fast tracking, SB 456, was sent to an interim committee for study. No update on that. And then the Senate Bill 571, which may or may not affect, it's where development and zoning regulations cannot apply to county-owned property within our city limits. That was set for a hearing today at 1:30. However, I've not checked, or there's not been an update since 1:30 on the House website. With that to say, the development code reform is picking back up as of this week. All of the technical review comments have been sent for 107 as of end of last week, and we're working on zoning code draft, the second draft right now, as well as the map. The draft of chapter 109 is already on our website. I've sent that to you guys for comment at the beginning of March. I haven't received any comments from you guys. However, staff is working on that second draft. And now we are starting to eye planning commission meeting dates for this code reform. I gave them 3 to choose from, depending on how much work we have left. I would love for this to come to you guys on June 14th, your June regular meeting, which means we would have to have a public hearing that day on that, and then potentially, should you recommend approval, go to council that month as well. The second option was the July meeting, and then the third option was, which is the less preferable, would love to have this through before August, the August regular meeting. And so that's kind of what we're looking at right now, and I will keep you guys updated on that, because once we set that public hearing date with you all, that will then set the other public hearings, or public input sessions, involvement sessions that we're going to plan before that. Because obviously we want the public and everyone, all of the, the committees, the boards, everyone that would be involved to see it before it actually comes to you in an official public hearing. So we have a few meetings to work out before that. So all that to say, keeping a radar on our June, July, and August meetings. Those work sessions may be long, whichever, depending one that we get it set on, which you will have a heads up on as well once it's firmly set, once we hear back from them when they give their opinion on where we are and how close we are. Do you have any questions on that?
You were flying through a lot of it.
I know.
The one bill that was trying to deregulate residential zones.
1754?
That's
Deferred.
not
Deferred.
moving forward at this point.
So it's
I don't
been-
think it's anything to worry about this time around.
Okay. That was actually the one I was the most concerned about myself.
Yeah, there were some proposals I think would have pretty much eliminated municipal zoning.
1754 would have
Yeah,
completely.
It was going to be significant.
Yes.
I think and just to supplement what Taylor said, and she mentioned it, but I think the most significant change you're going to see is just the removal of the planning area jurisdiction. The Dollar General, like we did right now, you're not going to see it. The medical marijuana that we did a few years ago, you're not going to see it. We're only going to see development that occurs in the city limits. And given our unique situation here in Bella Vista, I think that means you're going to see fewer large scales. Depending on what happens up and down the corridor, but seems like most of those sorts of projects have always been on the edge, and we're not going to have that anymore. So,
Are we looking at any annexations or anything like that?
there's been some internal discussion about approaching some property owners on the edges of some various places and in some interior locations to address potential annexation on the east side that are adjoining the city of Bella Vista, and I think those matters are under the mayor's advisement right now and in preliminary discussion with property owners and things of that nature.
All right.
If you don't have any further questions for that, I did just want to feel the temperature of interest of the administrative rezoning should the governor pass that. Essentially, this bill that is waiting to be signed into an act is a capability for staff to use internally to do administrative rezoning so long as the request is aligned with the adopted future land use plan. That would streamline development, and it's already basically the idea is if planning commission's already held a public hearing on it, they recommended approval and city council already approved it, then why does it need to go through that process again? And so staff can just approve it if it's aligned with your directions to staff already. However, if it's not aligned with the land use plan, then the rezone would come through a traditional rezone, planning commission, public hearing, city council up to 3 times, et cetera.
Well, it's been a while since I looked at it. Was that a mandatory thing, or is it gave us the option of creating it?
It is the option. It's a may.
Oh, okay.
Yeah, it's a tool. Should the city be interested in using it? So I'm curious on planning commission's immediate interest.
This is one of those where I know there weren't many lawyers involved in it. Ms. Portillo and I spoke about that. There is an entire body of decades of law that are clear that zoning decisions are legislative decisions. And as such, they can only be appealed to court. They would require council approval, as you know, and they can only be appealed to court if they are arbitrary and capricious, which is basically a standard that applies to any legislation. It's unconstitutional if it's arbitrary and capricious, which is a very high standard. So it gives the city council, rightfully, great deference. As long as there's some logical reason why they zone something a certain way, then that really can't be challenged in court. If we're going to say now that there are certain rezonings that are administrative, now I don't know what that does to that standard, because the appeal of administrative decisions is not on an arbitrary and capricious standard. And I don't know if they've addressed that in the statute or not. This is what I like to call a Lawyer Support Act of 2025, because there are lawyers that are probably going to end up getting paid to sort these things out that are created by the legislature. And I just see it as potentially being an issue. Having said that, I've not gone over the statute line by line. It could be they've also made amendments to those other sections. I'll give you the recommendation that I usually give as it relates to a lot of things. I'm not keen on Bella Vista being the first one so we can be the one to get sued. There are others who probably want to do that, and we can learn an answer to a question without having to incur those expenses and go through that fight. And perhaps it would be wise for us to sit back and see how those things flesh out before we move.
Yeah, I was going to say, I don't know that the commission needs to have an opinion until there's an opinion to have.
Yes. One, I don't think it was this one, but another, it may have been the residential zoning, that it talked about, it was just whereas there are all these arbitrary zoning designations throughout the state. Well, if they're arbitrary, then they're unconstitutional, and there are remedies now.
Yeah.
So there are these assumptions that anytime you zone, you're acting in contravention of property rights unreasonably and arbitrarily, and therefore unconstitutionally. And it looks like there's a large number of the legislature that just accepts that. They don't even ask whether that's the case. So, nor do they know a lot about the case law, because there aren't many attorneys in the legislature. So.
Yeah, and I think the other question that really has to be answered is how binding is the future land use map?
Well, it's not. I mean, it's a plan, and so you can deviate from the plan.
I know you say that, but interesting enough, there is a lawsuit that was filed in the city of Rogers where they did not follow their land use map.
And so there are, and I've provided this memo in the past, there are a large number of things you can consider in a rezone.
Yeah.
One of those is the compatibility with the land use plan, but that case at least doesn't say you have to do it to the exclusion of all other considerations. So I don't know anything about the facts of that case, nor how it was argued, or how it's going to end up.
Well, no, it was already settled and the apartments got built.
Well,
Rogers acquiesced.
okay, so it didn't go all the way up, so is that
Yeah, I think they ended up deciding they couldn't win, and they decided to settle it.
All right, well, there could be a lot of considerations behind that other than just that one thing, but it wasn't a pro-city planning legislature. I can say that, and I'll say this, and this doesn't apply to us, so I feel more comfortable in saying it. There are a lot of jurisdictions that have taken the term and the idea of planning well beyond what planning is.
I agree.
And if you're a city and you want to have a climate action plan, well, that really is a whole different political ballgame than we're talking about, our sewer planning or something. And so I think the extreme is what brings these ideas forward down Little Rock, and we're having to deal with that on the common issues now.
Yeah. Well, I like what you said. Let's wait and see what everybody else does. And if Governor Sanders signs it or not, she hasn't even signed it yet, so.
Correct, and this was just a temperature check to see if you guys were interested, like if there were any, and that's all that was. It wasn't an official direction or anything like that.
I don't know if she's going to use her first veto on that one, if she has a veto. I mean, seriously, if you think about the consequences.
I'm sure she probably doesn't care.
That's fine.
So-
We'll keep all the rezones the same in the current legislature, and we will sit back and watch, so.
We'll see what everybody else does. Cool. All right, anything else? All right, if not, I believe that, I already closed my book. City Council work session is April 21st at 5:30 PM with the regular meeting on the 28th at 6 PM. We will have another work session on May 1st at 4:30 PM with our regular meeting and our Board of Zoning Adjustments on May 12th at 4:30 PM. We stand adjourned. Thank you, everybody. Always appreciate all the minutes, Sarah.